Good morning, everyone. Thank you for joining me today. My name is Peter Doughman and I'm an associate at Matthews Folbigg Lawyers in Parramatta. Today I have the great privilege to talk to you about the subject of workplace bullying, what every employer must do. As you know, on 1 January 2014, the Fair Work Commission anti-bullying jurisdiction came into force, and that resulted in a statutory right for employees to pursue bullying claims into the Fair Work Commission. That right, as well as the increased incidence of reported bullying claims by employees, has resulted in this being a quite interesting and somewhat concerning area for a lot of employers. So now that we've had a few years under our belt to deal with those sort of claims, I think it's a good time to revisit the area and see what has resulted from the jurisdiction and what has changed over the last 3 or 4 years in respect of the jurisdiction. So what I'll be covering today are set out in these areas of focus. Firstly, we'll start with the definition of workplace bullying. Then I'll deal with what isn't workplace bullying. I'll deal with workplace bullying claims made in the Fair Work Commission. We'll look at some case studies. I'll look at the pointy end, ways to deal with workplace bullying claims made by employees and workers. And finally, I'll look at some ways to avoid workplace bullying claims and minimise the liability arising from those sort of claims. So let's begin. What is workplace bullying? Very helpfully, the Fair Work Act now includes an express definition of workplace bullying. Somewhat unhelpfully, given that it's the Fair Work Act, that definition is unreasonably opaque and complex. There's quite a few elements to the definition, which I'll go through now. The definition is set out in section 789FD subsection 1 of the Act and has various limbs. But essentially the definition provides that a worker is bullied at work if, while the worker is at work in a constitutionally covered business, an individual or a group of individuals repeatedly behaves unreasonably towards a worker or a group of workers, including the worker, and that behaviour creates a risk to health and safety. Now, the reference to unreasonably in that definition is important because the definition in the Act goes on to say that reasonable management action conducted in a reasonable manner does not constitute workplace bullying. So let's start with the definition of a worker. Unlike other aspects of the Fair Work Act, it's not limited to employees. People who can make claims of workplace bullying under the Fair Work Act include employees, but also extend to other forms of workers such as contractors, labour hire employees, apprentices, outworkers and volunteers. Importantly, the definition of a worker does not extend to people who are at the workplace for some commercial reason. For example, sales representatives visiting a workplace such as a retailer. Now that we know who's covered by the provisions, how are those people protected by workplace bullying? What is the test? Well, as I said, the worker must be at work. The worker must be at work in a constitutionally covered business. The worker must be subject to repeated behaviour. That repeated behaviour must be unreasonable. And the repeated unreasonable behaviour must cause a risk to the worker's health and safety. So what is at work? Well, at work is not defined in the Act, but it's the same expression used in the Work Health and Safety Act 2011. And that's helpful because we can use decisions from claims arising under that legislation to inform us as to what is captured by the concept of being at work. Basically, those decisions provide that being at work is not necessarily restricted to the workplace itself, or even where the worker is actively engaged in work. It can include, for example, being on a break, or where a worker is being bullied at a social media event, a social event, or when it's being subject to bullying via social media posts that are made outside work but are viewed by the worker whilst at work. What is a constitutionally covered business? Well, that one's a complex one, so we won't get too deep into it. But essentially, it includes businesses conducted by a constitutional corporation, for example, a company, a Commonwealth or a Commonwealth authority, and a body corporate incorporated in a territory. Now, based on my understanding of who's registered for today's presentation, I assume that most of you, if not all of you, are constitutional corporations or representatives of companies. So all of you should be covered by and subject to these anti-bullying provisions in the Act. What is repeated behaviour? This one's fairly straightforward. It requires persistent behaviour by the bully. It doesn't require the behaviour to be the same, and it allows that the behaviour may evolve or involve a range of behaviours over time by the bully. The only requirement is obviously that the behaviour has to be engaged in more than once. What is unreasonable behaviour? This one's a bit more difficult to ascertain and pin down because it requires an objective test. Unreasonable behaviour is behaviour that a reasonable person in all the circumstances may see or perceive as unreasonable. And finally, bullying is conduct that must create a risk to health and safety. There must be a causal link between the conduct and some form of injury or damage to the victim. Now, it doesn't necessarily require that the victim actually physically sustain damage to his or her health and safety. It's sufficient for the conduct or the behaviour to have the potential to cause danger to that worker's health and safety. So we've gone through the definition, and I'm sure it probably still appears quite dense and opaque to all of you. So helpfully, the Safe Work Australia has provided a guide for preventing and responding to workplace bullying. And that guide sets out a number of examples of workplace bullying, and reading through this list should helpfully give you a sense of the kind of conduct that should be unacceptable workplace bullying at any workplace. And just quickly going through that list, it includes abusive, insulting or offensive language, unjustified criticisms or complaints, deliberately excluding someone from workplace activities, withholding information, setting unreasonable timelines or time deadlines, setting tasks that are unreasonably below or above a person's skill level, and denying access to information and resources, spreading information or malicious rumours, and finally, changing work arrangements such as rosters and leave in order to inconvenience or cause adverse action to the worker or a particular group of workers. Important to realise that bullying conduct may be intentional or unintentional. It doesn't require that the bully knows specifically that the conduct he or she is engaging in is inappropriate or unreasonable. As mentioned above, a single incident of unreasonable behaviour is not considered workplace bullying for the purpose of the Fair Work Act. However, it does have the potential to escalate, and therefore it should be dealt with formally and efficiently and in an appropriate way using performance management guidelines or disciplinary action if necessary. And in that respect, if there's any incidents of express workplace violence, for example, physical assault or battery, as a first step, as immediate first step, that conduct should be reported to the police. Doing that doesn't absolve your responsibility to investigate and undertake a disciplinary action as appropriate, but the referral to police should be the first step that any employer takes in response to workplace violence. Finally, I've just put up on the screen a block quote from Vice President Hatcher in the often referred to decision of Amy Mack in Bank of Queensland, where the Commissioner, the Vice President, sets out what he considers to be forms of conduct and inappropriate bullying in the workplace. And you'll see it includes things like intimidation and coercion, malicious pranks, physical abuse, verbal abuse, harassment, ganging up, isolation, rumour mongering, and victim blaming and discrimination. There's a lot more examples there, and you can have a look through that and get a sense for what the Vice President considers to be a workplace bullying and is what has been used in a lot of cases by the Commission in dealing with these sort of claims. So we've gone through the definition of what is workplace bullying. Now we have to go through, now it's appropriate to go through and consider what isn't workplace bullying, because that will be important if and when you need to come to respond to claims or, heaven forbid, defending claims in the Fair Work Commission. So using the the definition of workplace bullying as a guide, we can see that conduct that does not satisfy the statutory definition includes conduct that is not carried out at work or has no connection to work. For example, any form of conduct engaged in by employees during a social event that has absolutely no connection to the employer or the employment. Conduct that is not repeated. So, for example, a one-off incident can't be bullying for the purpose of the Fair Work Act. Conduct that does not create a risk to health and safety is not bullying for the purpose of the Fair Work Act. Now, that one's more of a theoretical exclusion than anything else, because often when someone makes a complaint about bullying, that will involve a complaint that the employee is subject to stress and anxiety, or it's causing stress and anxiety, or has resulted in some form of medical or adverse medical reaction. Often results in the employee going off on stress leave or sick leave. And finally, conduct that does not satisfy the statutory definition of bullying is conduct that is not unreasonable. In the case of the employer, that includes reasonable management action. I'm going to focus on this particular point now because that's where a lot of the case law that's with an issue with a lot of the case law deals with. Reasonable management action is action taken to direct and control the way work is carried out. It is reasonable for managers to allocate work and give feedback on a worker's performance, provided the actions are carried out lawfully and in a reasonable manner. For examples of reasonable management action include setting reasonable performance goals, standards and deadlines, rostering and allocating working hours where the requirements are reasonable, transferring a worker for operational reasons, not selecting a worker for promotion where a reasonable process is followed, informing a worker about unsatisfactory work performance in an honest, fair and constructive way, informing a worker about inappropriate behaviour and conduct, likewise in an objective and confidential way, implementing organisational changes or undertaking restructures, and finally taking disciplinary action, including suspending or terminating employment. Now, in respect of all of those examples, it's important to ensure that an unlawful, inappropriate or discriminatory reason does not infect the decision or the process. For example, even though it may be reasonable management action to restructure and mark an employee for redundancy, if the redundancy or the decision to make a particular employee redundant is taken as part of a course of conduct of bullying, then that will not allow the employer to argue that the redundancy fell outside the scope of the bullying or otherwise constitute reasonable management action. So the takeaway is ensure that your decision-making is impartial, independent and not infected by any underlying bullying reasons or inappropriate reasons. So let's look at bullying claims conducted in the Fair Work Commission, because that's where a lot of these claims will likely end up if not resolved internally. So as I mentioned at the start, the Fair Work Commission's anti-bullying jurisdiction kicked off on the 1st of January 2014. And that jurisdiction essentially empowers the Commission it allows an employee, or rather a worker, who really reasonably believes they have been bullied at work to apply to the Fair Work Commission for an order to stop the bullying. Now that point is important. The sole purpose of the anti-bullying jurisdiction is to prevent further bullying. The Commission does not have the power to award financial compensation to the victim of the bullying. And it's for that reason, in my view, that the jurisdiction has been used a lot less than it was originally anticipated or intended, because it's not being used by aggrieved employees to try and obtain a beneficial exit payment when they see the writing on the wall in respect to their employment. However, it's important to note there are some other benefits associated with the jurisdiction for employees. Firstly, it's structured and cost-effective and it's accessible. Workers don't need to be legally represented and the proceedings are conducted as informally as possible. It's quick. The Fair Work Commission must start to deal with an application within 14 days of the application being commenced. There's no time frame for a worker to lodge an application, but the employment must be on foot at the time the application is lodged, or probably more accurately at the time that the application is dealt with by the Commission. And I'll come back to that point in a moment. And finally, it's important to realise that making an application to stop bullying is a workplace right, and is therefore protected under the general protections in the Fair Work Act. And I'll deal with that right at the end of the presentation, time permitting. So what powers does the Fair Work Commission have in dealing with these applications? Well, it can deal with the application in any way it considers appropriate. It can either contact the employer or the applicant after the application has been lodged. It can conduct a conference, and usually those are conducted in private unless the Commission considers it otherwise appropriate to do it in public. I would expect that would be unlikely in most circumstances. It can conduct a mediation or conciliation. I expect most of you would have been familiar with the Fair Work Commission's telephone conciliation process. That's a mandatory step in unfair dismissal claims. That's not a mandatory step in bullying claims, although the Commission may convene one if it's considered appropriate. The Commission can hold a formal hearing. It can make recommendations to the parties, and it can make findings or express an opinion. Importantly, and this is one that I think is more relevant and worthwhile for employees bringing these sort of claims, the Commission can make the decision to de-identify the parties to a proceeding if they consider it appropriate. And you'll see if you ever look at any of the cases and judgments handed down by the Commission in respect of these sort of proceedings, you'll occasionally come across one where a party is identified either by some form of pseudonym or just a set of initials. So in dealing with these sort of claims and exercising its power, the Fair Work Commission may dismiss an application for an order to stop bullying if the application is not made in accordance with the Fair Work Act. Obviously, the Act has certain statutory requirements. Those can include that it be done in a particular form and is accompanied by a particular filing fee. So if the filing fee is not paid and there's no waiver issue filed and accepted, then the application can be dismissed. If the application is frivolous or vexatious or has no reasonable prospects of success, if the applicant cannot substantiate that any bullying occurred, in other words, if the applicant failed to discharge the evidentiary onus that he or she was bullied in the workplace in accordance with the statutory definition of workplace bullying. And finally, the Fair Work Commission can dismiss an application if it's unable to fulfil its function to prevent further bullying. And that's, as I said earlier, the sole power of the Commission is to prevent further bullying. If the employment has terminated and necessarily the employee is no longer subject to or exposed to the bully or the cause for the bullying, then there's no reasonable basis for the Commission to continue to hear or consider the matter. When exercising its powers, the Fair Work Commission may inform itself of various matters by requiring witness statements as well as written and oral submissions, and that's how these matters are usually dealt with. It could require a person to give evidence or produce documents. It could hold a conference or hearing. In addition to that, it can take into account any investigations into any matter by another person or body, for example, work cover or the New South Wales or the police, regardless of the status of the investigation. It can also take into account the contents of any policies or procedures issued by the employer applying to the workers in an attempt to resolve grievances or disputes. So this would include, for example, our anti-bullying policies, codes of conduct, or potential terms in an enterprise agreement. Finally, the Commission can take into account in exercising its powers any other matters it considers relevant. That second point on this particular slide, referring to policies and procedures, is important. We would certainly recommend that as soon as possible and prior to any bullying claims ever being made, employers should ensure that it has appropriate policies and procedures in place and that those policies and procedures are drafted beneficially in favour of the employer and sets out a regime requiring the employee or the worker to pursue the matter internally before pursuing the matter externally, for example, in the Fair Work Commission. That will allow the employer to keep these sort of complaints in-house to the extent that it has the power to do so. Now, what can the Fair Work Commission do? Now, it has a broad discretion in respect of the orders it can make. Essentially, it can make any interim or final order it considers appropriate in order to stop the bullying or in an attempt to stop the bullying. However, as mentioned before, it can't make an order for the payment of compensation because that wouldn't necessarily stop the bullying from occurring. When making a decision or making an order, the Fair Work Commission must be satisfied that the worker has been bullied at work, and if the order is not made, there is a risk the worker will continue to be bullied at work. In addition to making those orders, the Fair Work Commission can refer the matter to the Work Health and Safety Regulator, for example, WorkCover, for further investigation, especially if it has serious concerns that the bullying conduct causes serious risk to health and safety. So let's look at some case studies. As I said, the Fair Work Commission's anti-bullying jurisdiction commenced on the 1st of January 2014, and in the 4 years since that time, there have been less decisions than anticipated, but there are quite a few that have come to hearing and that are somewhat informing and informative, and in certain respects a little bit concerning for employers. So these have been chosen in an attempt to identify some risks, pitfalls and traps to try and avoid falling into. So firstly, I'll look at the decision of Lynette Bailey. That was a decision from last year, 2017. Now, Lynette Bailey was employed as an executive director of Bendigo TAFE. Now, Miss Bailey made a bullying allegation, or a number of bullying allegations against various other directors of the TAFE in March of last year. And then after making those complaints, proceeded onto sick leave, alleging that the bullying resulted in her being unfit for work. After she had made the allegations, the TAFE turned around and levelled several misconduct allegations against her and proceeded to commence an investigation into those allegations against her in respect of her conduct. Now, the TAFE took care to make sure that the investigation was independent as possible. It conducted the investigation, or it appointed an external investigator to conduct the investigation, and it also ensured that the representatives of the TAFE who were overseeing and instructing the investigator weren't the ones named by the applicant in respect of her complaints. After the investigation, or in the course of the investigation being conducted, the applicant alleged that the investigation itself constituted further bullying against her, and applied to the Fair Work Commission for an interim order to prevent her dismissal. Obviously, it must have seemed to her that the investigation would have likely resulted in that outcome at the end. So the applicant claimed in her proceeding that if the interim orders restraining any decision to dismiss her weren't made, and she was subsequently dismissed, then the dismissal would inevitably deny her from being able to pursue a bullying remedy. That's because, as I mentioned, if the employee is not subject to the bully or the bullying conduct, then it is unable to deal with the matter further. Now, the TAFE responded to that application and that argument by asserting that the order sought was effectively an injunction, and that the Commission did not have a power to order an injunction, given it's one that can only be made in the normal course by the Supreme Court, which is a court of superior record in New South Wales. The Supreme Court of Victoria in this particular case. The Fair Work Commission acknowledged that any decision to dismiss Ms Bailey would seriously prejudice the applicant's ability to maintain her claim. So they did agree with her on that point. And the Fair Work Commission also noted that the applicant remained on leave at the time that she had commenced the claim, and separately to that, after the allegations were made against the applicant, the TAFE made the decision to suspend her on pay in order to allow the investigation to occur. So the Fair Work Commission considers those two factors supported the making of an interim restraint order against the TAFE. So in the end, the TAFE was subject to an order which barred it from taking any further action against the applicant in respect to the investigation, or to dismiss her at the conclusion of the investigation until her bullying claim has been fully heard in the Commission. Next case I want to look at is the decision of Darren Lacey and Chris Candelars against Murray Australia. As you are aware, Murray is a bus line company. So the applicants were both employed by Murray's in the position of bus drivers, and they claimed that the manager in the depot in which they worked was consistently engaging in unreasonable behaviour towards them. That included yelling and swearing and putting the workers down, and that conduct amounted to bullying. The applicants claimed that they had sustained an anxiety reaction due to the bullying, and claimed that prevented them from being able to perform their work. They also mentioned and cited and relied upon the fact that they are bus drivers and that their health and safety is inexorably linked to the health and safety of their passengers. After they'd made those allegations against the manager, other drivers who worked out of the same depot supported the claims of bullying and essentially substantiated that the manager was engaging in this form of conduct. And that resulted in Murray's changing the manager's position. So he's no longer responsible for managing or supervising or disciplining any of the bus drivers involved. Despite that step being taken, the drivers maintained that they could not return to the workplace while the manager was still present at the depot. So they obviously brought a stop bullying application in the Fair Work Commission. And in that claim, the Fair Work Commission found that the manager had in fact treated the drivers like naughty school children, quote unquote, which is unreasonable in the circumstance and thus constituted bullying. The Fair Work Commission acknowledged that the manager had been relocated by Murray's and had his position changed. So those facts in and of itself likely was to result in further bullying not occurring. However, the Fair Work Commission decided that it still considered it appropriate to deal with the matter and made a specific finding of bullying by the manager. And it did so on the basis that it believed that both the change in role for the manager and its formal findings of bullying on the public record was sufficient to protect the applicants, the drivers, from further bullying. So even though ordinarily the applicants were out of the scope of the bullying conduct, the Fair Work Commission still decided to proceed with its decision, make findings, and those findings were on the public record against both the manager and the employer. So that's an important one to bear in mind, that just simply fixing the problem may not result in you avoiding liability under these sort of claims. Next case I want to look at is the case of Catherine Burbeck and Alice Springs Town Council. That's another 2017 case. Now, the applicant, Ms Burbeck, was employed by the council in a public library as a Children's and Youth Services Officer, and she was required under this position to report to a particular team leader who she did not like or respect. Now, based on my reading of the judgment, it appears that those feelings arose following the applicant proceeding on to long service leave, and in the meantime, one of her colleagues was promoted to the position of team leader, so essentially leapfrogged her in seniority. And it appears that the applicant was dissatisfied by both the decision and the fact that this new team leader had lesser qualifications, tertiary qualifications than she did. So after she returned from long service leave, the applicant refused to comply with the respondent's procedures and processes, refused to follow the instructions of the team leader, and was generally dismissive about concerns about her behaviour after she engaged in this course of conduct. For example, the applicant made the decision to air her grievances about conduct she believed she was aggrieved, conduct she was exposed to that she was aggrieved by, in an email to the supervisor, but it included all staff of the library. And that was in response to a fairly innocuous email sent by the team leader, essentially the effect of all staff should treat each other with respect. So it was a fairly innocuous email that resulted in a very aggressive, pointed and direct response about her personal issues that involved all staff. Now, understandably, the employer considered that conduct inappropriate, and as a consequence of that act by the applicant, as well as other forms of conduct she engaged in, the applicant was subject to various forms of performance management disciplinary action. And this, of course, then resulted in the applicant proceeding on to sick leave, personal leave, due to stress. The applicant lodged a Fair Work Commission anti-bullying claim, and in a fairly comprehensive judgment, the Commission found that 4 of 6 instances of alleged bullying, or of performance management action, which the applicant contended was bullying, did in fact constitute unreasonable management action and thus bullying. The Fair Work Commission also found that these events over time, due to the continued breakdown of the relationship between the parties, caused the applicant increasing stress and anxiety, and thus cause a risk to the applicant's health and safety. So on that basis, the Fair Work Commission found that bullying had occurred based on the statutory definition of workplace bullying. However, the Fair Work Commission did take into account that the applicant had engaged in inappropriate, obstructive and aggressive behaviour towards the employer and decided to mitigate and modify the orders that it ordinarily would make in respect of the bullying. And essentially those orders included, firstly, in favour of the worker, the applicant, setting aside her prior and ongoing disciplinary action and delayed a performance review which she was being subject to or would be subject to in the near future. It also directed the applicant to attend counselling in respect of her conduct and behaviour and required the applicant to hereafter comply with the employer's code of conduct. So this was arguably a win or a loss for both parties. There was a finding of bullying by the town council in respect of what it considered reasonable management action, but it also, the decision did not cast the applicant in a particularly favourable light. The next decision I want to look at, or the next case I want to look at, is the one of Gain or King, and that's one from early this year. And Ms King was an employee of the City of Darwin, and in November 2016, she made allegations of bullying against 3 other employees. The employer then instructed law firm Minter Ellison to conduct an investigation into the alleged bullying, and it did so, and the law firm subsequently issued a report which substantiated the applicant's bullying claims to a large degree and made findings that the 3 other employees had engaged in inappropriate or unreasonable workplace behaviour. I don't think it used the word bullying in its findings, but I think that the finding was clearly that those employees had engaged in bullying. After the report was issued, the employer communicated the findings to all the parties. That included obviously the complainant and the applicant, as well as the employees concerned and named subject to the investigation. After that had taken place, the applicant filed an application to stop the bullying in the Commission, and as part of that application, sought an interim order for the production of the investigation report. Understandably, the City of Darwin opposed the order for production, claiming the report was covered by legal professional privilege. The City also claimed that the report contained sensitive information about the other employees and that should not be disclosed. That sensitive information related to both the employees in question, who were named as the alleged bullies, as well as other people who gave evidence during the course of the proceeding, course of the investigation. The applicant, Ms King, argued that by disclosing to the parties the findings of the report, the City of Darwin had essentially waived its right to legal professional privilege. And in that respect, the Fair Work Commission determined that the report was not legal advice issued to the council or the City of Darwin, and in fact was prepared by lawyers. The fact that it was prepared by lawyers did not, on itself, protect the report, and accordingly, the Fair Work Commission ordered the report produced, subject to the right of redaction or redaction process that the parties were required to comply with. So we've gone through those cases, and now you're starting to get a sense of how these decisions are dealt with and the sort of orders that are made. But now that we're getting towards the pointy end of the discussion today, I want to address how workers can, or employers can, deal with workplace bullying claims made by workers. So I'm going to go through a few steps, and I'm going to do it in a hopefully a fairly informal and quick way. But if anyone registered today and listening today has any questions about any of these steps, feel free to contact me. I'll also refer to another presentation that we gave, I think, last year, which relates to the conducting of investigations, and we'll deal with that in a moment. So step 1, this is obviously, these steps obviously are necessary after a complaint of bullying has been made. So you as the employer has received the complaint. It either may be in writing or verbally. So what do you do now? Step 1, you have to identify the parties to the complaint. Now this will usually be an easy process. The victim will usually be identified in the complaint or report, or that might be the victim who is the one handing to you the complaint or the report. However, be aware that complaints about bullying can sometimes be made anonymously, and that's true especially when the alleged bully is someone in a position of authority above the victim. Also be aware that a complaint may not necessarily name any or even all of the bullies, and again, that may be the case where the alleged bully is one in a position of seniority. And in that respect, I think it's helpful to set out what I consider to be the three most common forms of workplace bullying, and I've described them as both horizontal, vertical, and managerial. Essentially, horizontal bullying is where there's bullying conduct between employees or peers, and you deal with it as if it's a performance or a behavioural management issue between an employee. Vertical bullying is one between an employee and the employee's supervisor. And finally, managerial bullying is a claim where the employee claims that he or she is subject to unreasonable management action by senior management or by a representative of the company or the employer. Now, the difference between vertical and managerial bullying, in my view, is that in vertical bullying, the supervisor is clearly still part of the employee pool and is one who's appropriate to be subject to disciplinary action if findings are made against them. Obviously, that's a lot more difficult to do when you're proposing to subject a director, CEO, GM to disciplinary action for bullying claims that have been proven against that individual. In respect of managerial bullying, it's still important to ensure that you respond reasonably and appropriately to those claims and, to the extent that you can or if considered appropriate, deny those allegations. But assuming that it's horizontal bullying or vertical bullying, the next step would be for you as the employer to take initial steps to stop the bullying. Firstly, you should put the accused on notice of the allegations and issue relevant directions to that individual or those individuals. For example, if the complaint of bullying has been made against a supervisor in respect of an alleged performance management process which the employee or the worker considers to be a manifestation of the bullying, it might be appropriate to inform the supervisor to postpone that performance management process until the investigation into the allegation of bullying has been conducted and concluded. Question, should the accused be suspended? Now, that should be determined by reference to the contract terms, but it's usually a good idea, especially if the allegations are serious. Now, the reason why I mentioned that you should check the contract terms first is that at common law, an employer does not have an implied right to suspend even with pay. So even though it's a very common occurrence, it's possible that if you suspend an employee where you don't have an express contractual right to do so, that employee may argue that that constitutes a breach of contract. In addition, should you place the victim or the complainant onto leave? Now, it depends on the circumstances, but your priority should be on ensuring the health and safety of the victim. And so erring on the side of caution and to ensure you comply with your obligations in respect of health and safety, it's probably a good idea to place the victim or the complainant on leave. And it's important to make sure that that's characterised as what we would call special paid leave, rather than requiring the employee to utilise his or her accrued and untaken annual leave. If the employee decides to, of his or her own volition, claim to be unfit due to the bullying and ask to take their own personal sick leave, then that's another thing. But in the absence of that request from the employee or the medical evidence, it's appropriate, or it would be appropriate in most cases, to place the victim onto leave, especially if the conduct is serious. Whatever you do, make sure you don't delay in exercising those steps. The reason for that, obviously, is that any delay may exacerbate the bullying and increase the risk to health and safety. If you take no action for 3 weeks, the bullying may evolve over time, become more serious than the complaint, than that subject to the complaint. And in addition to that, delaying dealing with allegations of bullying may undermine or prejudice any finding of serious misconduct you may make in the future. There are cases of unfair dismissal where an employer dismisses an employee for serious misconduct, but it hadn't taken any steps to put the employee on notice of the serious misconduct for several months before it ultimately made the decision to dismiss terminate the employee's employment without notice. So delay will obviously affect the potential bullying claim and also undermine and limit the options you can take when you ultimately do need to take that action. Step 3 is you must conduct an investigation into the bullying claims. Now, I could spend an entire hour dealing with conducting investigations. In fact, I have. And so firstly, I'd suggest that you are interested in this process, refer to our website under Media and Webcast. There you'll be able to find a prior webinar headed Conducting Workplace Investigations, Why, When and How, which sets out exactly how an employer should conduct investigations into conduct or behaviour, not limited to bullying, but those principles still apply. However, what I will say now is that it's necessary and certainly appropriate to ensure that any investigation conducted is transparent and thoroughly documented, it's objective and not predetermined in any way, is conducted in a procedurally fair way, is not conducted by the accused bully, and that's relevant for vertical or managerial bullying claims. So you may need to isolate or quarantine the alleged bully from any decision-making power or process. And finally, the investigation must be conducted in a way that will not injure or prejudice the victim or the accused. And don't forget the accused right in all this in the process. Step 4 would be to take disciplinary action as appropriate against the worker if there's a finding that the worker or the employee has engaged in bullying or other inappropriate behaviour. So the available forms of disciplinary action include workplace training, engaging in performance or conduct management, issuing a verbal warning or caution, issuing a written warning, and that could include a first and final if the matter is sufficiently serious, or obviously dismissing the employee or the worker. Now, remember that if you're contemplating dismissal, dismissal will obviously give rise to a potential unfair dismissal claim. So ensure that the employee or the worker in question is afforded all procedural fairness, appropriate procedural fairness before the dismissals take effect. And in that respect, I'd recommend that at the very least you issue the accused with a show cause letter before the decision to dismiss is made. If you do proceed to dismiss the bully after the finding has been made, ensure the accused receives written notice of termination, and that's a requirement of the Fair Work Act. Of course, that doesn't apply if the employee in question is a casual employee. And I would certainly recommend the letter of termination expressly set out and confirm the decision was based upon the findings of the investigation and specifically the findings of workplace bullying. If there's nothing mentioned in the termination letter, that vacuum may entitle the employee to make an argument, usually in the context of a general protections claim, that the dismissal was for some other reason. Finally, if the dismissal is based on a finding of serious misconduct, be aware that the accused will not be entitled to notice of termination or payment in lieu of notice, but the employee will still be entitled to his or her accrued and untaken annual leave, and in certain circumstances may not be entitled to receive their pro rata long service leave. Now, the long service leave issue will depend on which state or territory you're based in, because long service leave is state-specific, but essentially in New South Wales, an employee who is terminated for serious and willful misconduct will not be entitled to their pro rata long service leave between 5 and 10 years. Once they've hit the 10-year anniversary, then their entitlement to be paid out their long service leave, to the extent they haven't already taken it, is a statutory right. Finally, I'll deal with the issue of avoiding workplace bullying. First step, and the most important step you can take, is to institute a bullying and harassment policy. Now, that policy should cover subjects such as bullying, harassment, and that should include sexual harassment, as well as discrimination. And you should provide definitions and examples of each of those limbs, so examples of bullying, harassment, and discrimination. The policy should identify clearly the person or persons to whom the complaint should be directed, and we typically recommend that there be 2 layers of reporting line to deal with the potential issue where the person to whom a complaint or bullying would normally be directed is actually the person engaging in the bullying. So, for example, if it's not appropriate to refer or make the complaint to the supervisor because the supervisor is the one engaging in the bullying, then there should be someone else higher in senior management to whom the complaint should be made. The policy should set out the employee's obligations, and that obviously includes the prohibitions on the defined conduct. So you shall not engage in bullying, harassment and discrimination as we define it, and as we've given examples about them. Obligation to report any observed bullying conduct by others. So even if you're not engaged in the bullying or you're not the one subject to it, the employee may have an obligation to report that. And finally, the obligation of an employee to assist with any investigation being conducted into bullying. For example, if you're an eyewitness to bullying, you may have to assist, give evidence, make a statement, etc. Also important is to ensure that the policy expressly prohibits retaliation, victimisation or reprisal after if an employee is subject to a bullying complaint, and also prohibits making false reports about bullying. The policy should also include these, what I consider administrative clause or administrative provisions. That includes a coverage clause. Does it just cover the employees? Does it extend to contractors and volunteers? So if you do engage a lot of independent contractors in your workplace, or else volunteers, then ensure that the parties defined and the parties covered by the policy are defined as workers, for example, and use that definition because it's the one found in the Fair Work Act. Include other definitions as appropriate, for example, us being the employer, workplace, what is the workplace, what is disciplinary action, what rights does the employer have to take disciplinary action. Include a clause that allows the employer, you as the employer, to amend, replace or withdraw the policy from time to time, and make clear that the policy does not impose contractual obligations on you as the employer. I'd also recommend that you include an acknowledgement form so that it's a requirement that all employees or workers sign that they have received, read and understood the policy. That way there can be no argument that the worker in question or the individual in question was ignorant of their obligations or the prohibitions on certain forms of conduct. And finally, it's important and indeed imperative to ensure continued and consistent compliance with the policy. That's both by workers, so ensure that ensure that you police workplace behaviour, but also make sure that it's being policed uniformly and consistently. Don't enforce it formally against one employee whilst letting other employees get away with the same sort of behaviour. What other protective steps can you take? Well, firstly, you can institute a code of conduct which sets out expected and acceptable behaviour. This is a bit less formal than a bullying policy, but sets out expectations of the employer in respect of workplace conduct. And again, make sure you apply any code of conduct consistently and impartially. You should also undertake regular workplace training or workshops on bullying, and I recommend you undertake that sort of training at least once every 1 or 2 years. Ensure that any management action taken, especially disciplinary action, is conducted fairly. Ensure that you continually monitor workplace behaviour, staff morale or organisational culture, because doing so will give you the first signs that bullying may be rife within the workplace, even before a complaint is made. And finally, and as I mentioned earlier, incorporate into a policy a requirement that any bullying claim should or must be reported internally before the employee or a worker may make a formal external bullying application to an external court or tribunal, for example, the Fair Work Commission. How can you minimise damage from workplace bullying claims? Well, you can ensure that your employment agreements contain express duty not to do or say anything that will bring the employer into disrepute. And we often find that if an employee has been subject to bullying, that employee will lash out on social media and complain about the employer letting other staff get away with it. If the matter is the subject to investigation, the parties to the investigation must be directed to ensure that the contents of the investigation and any other dispute is kept strictly confidential. And we'd recommend this be also confirmed in an applicable policy. As a recommendation, we certainly recommend you be seen to be active or interested in resolving workplace disputes. Of course, if an employee sees that, it's less likely to pursue the matter externally. And finally, I recommend you have in place an IT or social media policy that avoids the risk of employees complaining about the workplace, other staff, or the employer generally on Facebook or other forms of social media site that may cause you reputational damage. And finally, I just wanted to touch very briefly on the general protections under the Fair Work Act, because you'll often find that by dealing with a bullying claim, you might jump out of the frying pan into the fire. Essentially, the general protections protects employees from adverse action taken for prohibited reason. Now, adverse action is defined within the general protections as dismissal, demotion, prejudicial alteration of their position, injuring employees, or discrimination. And the prohibited reasons can include employees' exercise of workplace right, and critically for us, making a complaint or inquiry in relation to employment is a workplace right. What is also a workplace right is making an application to the Fair Work Commission to stop bullying. So putting all these things together, the general protections prohibits an employer from subjecting that employee to adverse action because that employee made a complaint about bullying or commenced a bullying application. Now, unlike a bullying claim in the Fair Work Commission, general protections claims proceed into a court. They can involve payments of significant compensation, and they're far more costly and difficult to defend, especially with a reverse evidentiary onus. So I'd certainly recommend that if you're subject to bullying complaints, be careful against subjecting that employee who made the complaint against any form of disciplinary action, but especially dismissal. Otherwise, you will likely find yourself subject to a general protection or adverse action claim. So that's my presentation for today. I think I've got about 7 or 8 minutes left to answer any questions. I haven't looked at the questions yet, so I might just have a quick look at them now and see if anyone's asked anything that we should cover now or haven't already dealt with. Just bear in mind. Okay, so I've got a question that what can we do if an employee makes false allegations of bullying against other employees? So this question gets asked quite a lot, and firstly, it's important to make sure that you don't predetermine that an allegation of bullying is false. Even if you suspect that it might be, for example, if there's an ongoing history or pattern of dispute between employees, you can't rely on that knowledge to assume that a bullying claim is false or vexatious or intended to damage the other employee. It's still, unfortunately, necessary to undertake that investigation and to make findings. Those findings should be made impartially, independently and objectively. And if after the investigation is conducted and the findings are made that the allegations of bullying are false and indeed are vexatious or unreasonably made, then you have a right to subject that employee to disciplinary action. Now, it's critical to ensure that when subjecting the employee to disciplinary action, you don't bring into your decision-making or into your reasons that the employee had made the complaint. You need to limit it specifically to the conceptual issue that the complaint made was false or vexatious. The reason I say that is, as I mentioned a few moments ago, if you subject an employee to adverse action, which could be disciplinary action, because they'd exercised a workplace right in complaining, then that gives rise to a general protections claim. There have been decisions dealing with and being able to separate between a workplace right being exercised by making the complaint and where the complaint has been vexatious or baseless. So make sure you focus specifically on the baselessness of the complaint, not the making of the complaint itself. I also suggest that you make clear in a policy, as I mentioned, for example, a bullying and discrimination policy, that the making of any false complaints will not be tolerated and will result in disciplinary action. That will give you a more formal and stronger basis to take that action if you need to. there's a question that, can I simply stop a bullying claim by terminating the employee before any claim is filed? I'm not sure where that question was asked, but the answer to that question is yes, but yes, you can prevent a bullying claim in the Fair Work Commission by terminating, but it's certainly not a good idea. And as we looked at the last slide, simply subjecting an employee to adverse action, for example, dismissal or other forms of adverse action, because the employee had made a complaint, or to prevent the employee from making a complaint, is in and of itself unlawful under the general protections. So you certainly would be jumping out of the frying pan into the fire by doing that. Because a bullying claim in the Fair Work Commission is far more informal and doesn't allow for orders of compensation, I would take the hit in dealing with it in the anti-bullying jurisdiction than potentially have to deal with a far more costly and more stressful claim of a contravention of the general protections, which may proceed into a court. And we have 3 more minutes. I'll answer one more question. Okay, so I have a question. Is it possible to reply with a bullying claim with a counter-bullying claim? So yes, you can. And as I mentioned a short while ago, each claim that's been made should be should be independently and objectively investigated. Now, I'm not sure by this question whether the counter-bullying claim is one made by the employer or a senior representative of the employer or just another employee. And I might contact the questioner in the next day or so and follow up on this, so that's fine. But I would say that if there are 2 employees that are in continual dispute with each other, one makes a complaint of bullying against the other, and the other then makes a complaint of bullying back against the first worker or employee, you as the employer still have to genuinely investigate and objectively investigate those. However, it might be a finding that the second complaint made by the counter-bullying claim, as it were, was made in reprisal or as a form of revenge against the first bullying claim. So be aware that if there's no basis for the second claim, then there may be a basis to pursue disciplinary action against that second worker or employee for lodging or making a bullying complaint vexatiously or as a form of reprisal. So I hope that answers that particular question as well. There are a few other questions in my list, but I think I've just run out of time, so I'll contact those individuals individually. I hope everyone got some good information about this today. And finally, I want to thank you for registering and being here with me for the last hour, and have a good day. Thank you.